Welcome to GNCC Espresso Live, a webinar series committed to providing information and guidance to deal with this rapidly changing business community. My name is Mishka Balsom, and I'm the CEO of the Greater Niagara Chamber of Commerce. COVID-19 impacts all of us. Immediate priority is the public health response. All levels of government have implemented the necessary protective measures: social distancing, self-isolation, closure of non-essential businesses, and much more. This has resulted in an almost immediate change in how all business and all organizations are conducting their business. It is our goal today, in today's webinar, to provide more clarity around legislation and obligations when it comes to the many and immediate workplace changes that many employers are experiencing: temporary layoffs, adjusting work schedules, liabilities from working from home, and more. To provide you with greater clarity, it is my pleasure that I've been joined today by Leanne Standryk, partner with Lancaster, Brooks & Welch. Leanne, thank you very much for joining us this morning.
Good morning, Mishka, and thank you for having me.
For all of you, for all the participants, we're utilizing Zoom technology, and I just wanted to give you a little bit of information that might help you. If you have a question, you will find on the right-hand side of your screen a symbol of a hand. By clicking that hand, it gives us an indication that you have a question and that you would like to ask that question. And secondly, you also have the option actually of typing in a question. There's a field at the bottom of the right-hand side, which you can see, and the questions will be seen by the panelists of today's webinar. So please utilize that. Many of you have also provided us already with questions via email, and thank you for those. We are truly committed to answering as many as possible. All the questions which will be discussed during the webinar are solely intended to inform some of the topics of discussions that we have today. We cannot consider it to be legal advice due to the solicitor client confidentiality situation. So we'll just try our best in providing as many answers as possible. Some of you have also indicated that the questions can be of a sensitive nature. If you are typing in a question and would like to remain anonymous, please indicate so, and we make sure not to mention your name. All right, and I think, Leanne, we are ready to move into some of the questions that we have. At yesterday's news conference, Finance Minister Monod actually expanded more and provided more information on the Canada Wage Emergency Subsidy that was announced last Friday. But what happened as well is that it has left some businesses with some additional questions. And here is one of the ones. If an employer has already laid employees off and now has the potential to bring them back with the subsidy, the 75% subsidy, but cannot afford to top up the additional 25%, do employees have a choice between EI or this particular subsidy and the 75% wage? Do they need to agree to go back to work, or do they have a choice?
So let's start off with the premise that those employees have already been laid off. The employer has the right to conduct a recall within the temporary layoff timeframes outlined in the Employment Standards Act. Upon doing so, of course, it's important for the employer to advise the employee of the 75% wage subsidy. The federal government indicated very clearly yesterday that it had hoped that the developments would help employers rehire workers who had been previously laid off, and they encouraged employers to utilize the program and make their best efforts to pay the remaining 25%. But they acknowledged specifically that some employers just may not have the ability to do so. So when we go to the question about whether or not an employee must return, I think that becomes a practical question for the employee. A recall has been conducted. In response to the recall, the employee is required to return to work. And from an economic standpoint, then the employee should consider whether 75% of their wage is better than receiving EI at roughly 55% of their wage up to a certain maximum, weekly maximum. So I think it becomes a practical question for the employee, also knowing that if they do refuse to return to work, that could be construed as a resignation from their employment.
That's very interesting, because that was a follow-up question that one of our business had as well, as saying, like, at what time is it a resignation? Now, an employee, if they only receive 75% of their wage, would they have been, can they consider to be constructive dismissal?
So let's start from the premise of understanding what a constructive dismissal is. A constructive dismissal is a unilaterally imposed fundamental change to a material term of the contract. So that means that the employee has not consented to that change. And the constructive dismissal as well is considered within the context of the environment in which we're working. So at this point in time, while the employee is only receiving 75% of their wage, if they have consented to that, then we are not in a circumstance of constructive dismissal. If they have not consented to the 75% wage, or the wage reduction, we'll call it, then query whether or not that employee is acting reasonably in the context of their duty to mitigate. We know that where a termination occurs, whether it's a wrongful dismissal or a constructive dismissal, while that instigates certain obligations employer obligations, we know that the employee has a duty to mitigate, which means take reasonable steps to minimize the damages that flow from the dismissal itself. A refusal, or let's say an objection to the wage reduction, may not be considered reasonable in today's climate of a pandemic.
That's an interesting distinction actually there. The other follow-up question, same topic related to it. If an employer can only offer basically the 75% pay, are they able to cut back the hours or the workloads to match that?
So again, when we look at a change to workload, we look at change in hours, we look at any of those material terms of a contract. If the employee consents to those changes, then the employer has been able to mitigate the risk of a constructive dismissal. If they do not consent, there is a concern of constructive dismissal. So what we've been advising our clients is engage the employees in the discussion, obtain their feedback, consider their feedback.
Yeah, I think that's very helpful on the same one, but it does leave some business with the questions and how to move forward. But I like your suggestion actually of engaging the employee in the conversation that is there, and how critical it is in establishing these new guidelines and this new understanding under these new circumstances that we're all finding ourselves in. I really do appreciate that. There's quite a few questions regarding legislation around layoffs, and one of the ones that has come forward is, under what circumstances and for how long are employers allowed to temporarily lay off people, and with what provisions?
So the Employment Standards Act, we all know, entitles an employer to lay an employee off for a prescribed period of time. After that prescribed period of time, the layoff is a deemed termination of employment, and the employee is entitled to termination and perhaps severance, depending on the circumstances. A temporary layoff is a layoff that is up to 13 weeks in a 20 consecutive week period, or it can last up to 35 weeks in any 52-week period if the employer continues the employee's coverage under a group or employee insurance plan, or retirement, or a pension plan, if the employer provides substantial payments or supplementary unemployment benefits to the employee during the period of layoff, if the employer recalls the employee within that time approved by the Director of Employment Standards. There's a whole series of circumstances in which the employer may avail themselves of the longer period of temporary layoff. Now, what's important to understand is, notwithstanding the fact that we have these temporary layoff provisions in the Employment Standards Act, it is important for employers to look at whether or not the employee agreement has a contractual provision permitting the employer to conduct a layoff. if there's no express contractual provision in an offer letter, employment contract, or an employment agreement, the very fact of a layoff without the employee's consent may trigger a constructive dismissal. Now, that being said, again, earlier I talked about the employee's duty to mitigate, so that if the employee objects to the layoff, that may not be construed as reasonable in today's climate, given the fact that we know that during a pandemic, it is most likely difficult for that employee to secure alternate comparable employment. So it may be more appropriate for that employee to accept the layoff and wait for the recall.
You know, Leanne, you're touching on a really important topic, because this was one of the topics that quite a few businesses had actually inquired about, because for so many businesses, not just small and medium size, I've also spoken to employers of bigger size companies, who weren't in the practice of ever temporarily laying off individuals, they did not have that clause in their contract agreement. I do believe moving forward that most employers will include it and now will add it to it, but they didn't have it at the time, and therefore felt vulnerable in exercising a temporary layoff, but couldn't also see themselves moving their business forward without having to take that measure. So thank you for clarifying that. Do you believe that moving forward, most employers now will include it in their employment contract?
I think that,
yeah.
Sorry, Mishka. I think that most employers will want to look at introducing the layoff provisions or a contractual right to conduct a layoff in their employment agreements. However, in doing so, what we know is that if it's not a pre-existing term, then that is the introduction of a new term of employment that restricts employees' entitlements within that relationship. And so very careful consideration has to be given to how the employer is going to implement that new provision. Because if they don't do it with appropriate contractual consideration, so provide the employee with a benefit in exchange for their agreement to these more restrictive or prescribed terms, then that provision may not be considered enforceable if scrutinized by a court down the road.
Yeah, that's a very good point. I just wanted to say that we had one of our attendees had asked a question, and it was a follow-up question to the 75% subsidy. And we were being asked, would this apply to independent contractors as well? And what element or where do independent contractors fit in when it comes to that element of a subsidy?
With the Canadian Emergency Wage Subsidy, what we know at this point, and it's important to understand that the terms of the legislation are continuing to evolve. I believe that they're still drafting the particulars of the entitlement. But what we know is that the wage subsidy is available to Canadian employers who are for-profit, not-for-profit, charities, and so forth. In terms of an independent contractor who may not employ other individuals, that individual or that independent contractor may have eligibility to access the Canada Emergency Response Benefit.
Yeah. That makes sense. Just a reminder that this is just really a discussion. All the answers that are coming forward or the discussion that we're having can really not be seen as direct legal advice to anyone. And we really need to be clear on this. This is coming from Sarah, one of our attendees. And we're being asked, or the question is, does the employee have to be physically working at the workplace for the 75% wage subsidy to be in place? And then there is a follow-up to this one. If a business is currently shut down, can the employer put the employee back on the payroll at 75% and not have them physically in the workplace, and those employers still qualify for the wage subsidy? It's an interesting question.
It is. Let's deal with the first question. If you can just restate that for me?
Yeah,
Sorry, Mishka.
no, I would actually, does the employee have to be physically in their space of work, in the place of work, to be able to receive the 75% subsidy? Or can they basically, because the business is shut down, can the employer put the employee back on the payroll at 75%, but not have them physically in the workplace?
Okay, thank you. Let's look at the fact that while the government has mandated closure of non-essential businesses, the purpose of that mandate is to enhance the rules around physical distancing, to minimize the touch points for social contact and spread of the virus. It doesn't mean that that employer cannot continue to perform or cannot continue in its business. It may do so through remote work from home arrangements. So essentially it's a storefront closure, if you will. So if that workplace has individuals that are working remotely from home, we understand that the Canadian Emergency Wage Subsidy is available for those employers, notwithstanding the fact that employees are working from home.
Yeah, that makes sense. There's also the question that has come forward and that it requires clarity in that do employers need to reinstate an employee basically full-time, or can they also just say I'm maybe more in a part-time basis or a few hours a week and still take advantage of the subsidy that is there?
Those are details that we do not know yet.
Yeah.
So we are all waiting for greater detail and understanding and direction as to whether or not that is going to be possible. Understand as well that when we talk about reinstatement to the workplace, different rules or different legal obligations may apply depending on the reason why the employee is not in the workplace. So what we saw in March was the Ontario government passed legislation called the Employment Standards Amendment Act, which presented emergency leave protections in response to COVID, such that if an employee is not currently in the workplace because of a positive test, or they're required to provide care to an individual who has tested positive, they're out of the workplace for essentially a COVID-related reason. What we know is that those are now being treated as job-protected leaves, meaning that upon return to the workplace, the employer has an obligation to ensure that that individual is reinstated to the pre-leave conditions.
Yeah, that's very helpful. This is a question that also doesn't relate to the Canada Wage Emergency Subsidy, but it relates to, it's in the same line of what we're talking about right now. What can an employer do if an employee refuses to work, owing to maybe those circumstances that they find themselves in?
So where an employee refuses,
in some cases, one of the areas that we've been hearing from some of our members in the construction industry, on the construction sector that are there, as well as some of it related to grocery stores.
right.
So there are employees who are refusing, who are and rightfully owing to fears that they have due to COVID-19.
Right. So work refusals are dealt with under the Occupational Health and Safety Act. And we know that certain individual employees do not have the right to instigate or initiate a work refusal. Those employees are typically police, firefighters, healthcare workers, long-term care, or group home employees. There's a series of them that are considered essential. But other employees typically do have the right to refuse work or to perform work if they hold what's called a bona fide belief of a physical condition in the workplace that presents a risk to their health and safety. What we saw with the tribunal in 2003 in response to SARS was that while we know typically that the work refusal is in response to a physical risk in the workplace, the tribunal actually permitted refusals and dealt with refusals in response to concerns or fears from SARS in the same manner. What we're seeing now is the tribunal doing the exact same thing in response to fear for concern of COVID-19. So what happens in that circumstance? Generally, what has to happen, or the practical steps, is the employee confirms the work refusal. The employer must ensure that that employee is put into a safe place, so whether that's at home or still in the workplace, but in a confined spot, so that they are available for an investigation. The employer must then ensure that they investigate the concerns of the employee and the circumstances around the refusal. Now, what they need to understand is that if they are unable to resolve the employee's concerns, and the employee maintains that there are risks in the workplace, then what has to happen is the employer has to call the Ministry of Labor. And then what happens is the Ministry of Labor will conduct its own investigation into the work refusal. And should the ministry confirm the absence of a risk, the employee who has engaged the work refusal may be disciplined if they do not agree to return to work. So there's a very specific prescribed process that employers have to follow.
Yeah, that has been very helpful, because this particular question has come up numerous times over the past few weeks. And so thank you very much, Leanne. This is from one of our today's attendees. If a business operates with mostly self-employed and contract workers, is the business able to apply for the 75% wage subsidy and keep them working? And this has been a repeated question. This has come up a number of times, and I see even a few other attendees actually asking the same question.
It's unknown at this point. What we do know is the wage subsidy is for employers to provide the subsidy to employees. So we do not yet have clarity as to whether or not that is going to apply to independent contractors. And again, independent contractors are typically individuals who are operating their own business, and therefore do not typically fall under the definition of employee as we know it. And as set out in the Employment Standards Act. So again, sit tight. We're not too sure where the government is going to go with that.
Yeah, sounds good. I'd just like to remind everyone that the answers given on the webinar do not constitute legal advice, and that before anyone takes any actions, we strongly advise them to consult, advise you to consult with your lawyer, with your own lawyer. And we have a hand up, and this is from Alan Dixon. Alan, I've just, the mic is all yours. Alan, can you hear us? I think, hold on one more time. I think we should be able to.
Hi.
Oh, perfect.
Hi, sorry, it's Anne. So we have an employee that was put into compulsory confinement after travel, so then applied for EI. We don't have a clause in our contract for layoff. So it's now coming up to the end of that 2-week period that he was put in confinement for, and he is safe. So as we don't have a clause in the contract, we don't actually have work for him at the moment. But do we need to bring him back in and apply for the 75% subsidy because we don't have a clause in his contract to allow us to lay him off?
Thank you for the question. I think, again, what is important is that I'm not able to provide specific legal advice to those circumstances. I can provide you with some general advice. So again, I apologize for that. There are certain ethical obligations that inhibit my ability to do so. That being said, where an employee is required to quarantine or self-isolate pursuant to the government directives, again, those employees are typically entitled to access employment insurance benefits, whether that's sick benefits or STD through the employer plan that may be in place. After that period of quarantine or self-isolation, typically they will be entitled to return to work. However, if the workplace circumstances are such that the employer has conducted company-wide layoffs, again, whether or not you have a contractual provision, or has laid off non-essential positions, and regardless of the employee's, I'm going to call it a medical leave, that employee would have been subject to layoff, then it seems to me that the employer would communicate the circumstances of layoff to that individual.
Thank you.
It's one related question that has come in via the chat opportunity, and maybe that just requires further clarification. Are employers obliged to pay staff who are self-isolating or quarantined?
So self-isolation or quarantine, we have been advising employers that there's no obligation to continue their regular wage rate, unless, of course, the employer has been able to engage that employee in a remote from home work arrangement and they're performing work, in which case there is an obligation to ensure that they continue to receive their wages. If the employee is unable to work remotely from home, there's no obligation to continue their regular pay or their regular salary that would have been paid in the normal course. Of course, what should happen is that employee should be provided access to sick benefits if the employer has them, provided information with respect to employment insurance benefits that may be available. The employer may also provide that employee with the option to access accrued vacation pay to supplement or provide a financial bridge during that period of time, but the employee cannot be forced to access that available vacation pay.
Yeah, that makes sense. There is another question that has come forward. There's a business in Niagara. They have a worker who has compromised immune system, and he has decided it is best to stay at home out of fear of COVID-19. He's not refusing to work, but feels it is best to stay home. He has been deemed essential to the business, and they have a very small workforce, and the employees do not deal with the public. But do they really have to go through the work refusal process with the MOL?
Sorry, Mishka. In that circumstance, what the employee has indicated is they may have an underlying medical condition that creates a vulnerability. In those circumstances, we have been advising our employer clients that they should treat that in a similar fashion as an employee who has been requesting an accommodation under the Ontario Human Rights Code in response to what's a medical condition or a disability. So the process would involve collecting some information from the employee with respect to the nature of the medical condition. Diagnosis typically is not permitted, or information with respect to diagnosis is typically not permitted. So try and understand the nature of the concern. Consider whether or not individualized accommodation is possible by way of, again, a remote work from home circumstance. If remote work from home arrangement is not something that is viable because of the nature of the work or the duties and responsibilities performed by the employee, consider whether or not allowing the employee to report to the workplace during non-peak hours might be something that would be reasonable in the circumstances. Again, the accommodation process, as we know it under the Ontario Human Rights Code, is something that doesn't require perfect accommodation, but something that's reasonable in response to the employee's concerns.
That makes sense. And while we're on the topic of working from home, now that many employees are working from home, what are the employer's liabilities as it comes to any accidents that the staff member might have in their home office, or now that they're conducting work for the employer out of their home?
That is a great question. What we have been doing is we have been advising employers to ask the employee whether or not they actually have an insurance rider within their home insurance to cover any concerns of injury that may occur as a result of performing work in the home. So that's number one. Number two, employers should check with their own insurance provider to determine whether or not there's appropriate coverage, and or make the necessary inquiry of WSIB.
Yeah, I think it's a very good question. This is a question from Christine here, who's with us today. Thank you. What if an employee is to return to work after self-isolation, but has now sustained an injury that prevents them from doing their job?
Okay, so in those circumstances, employers would typically deal with that issue in the same manner that they would deal with an injury or a medical concern outside circumstances of a pandemic. So that would involve the employer engaging the employee in the accommodation process as we know it under the Ontario Human Rights Code. And that is specific to each circumstance. So it's a case-by-case analysis. You engage the employee, you obtain the relevant information with respect to limitations and modifications, have an open discussion and dialogue around what reasonable accommodation looks like. And again, it's not to a standard of perfection, but try and think outside the box.
Yeah.
As well in those circumstances, sorry, Mishka, in those circumstances when employers are responding to an injury or a need to accommodate a medical concern, what's critical to that process is information from the employee's healthcare practitioner, because it's that healthcare practitioner who is able to provide that objective assessment of what the limitations and modifications are that the employer has to consider in developing a reasonable accommodation plan.
Yeah, that makes full sense. We're being asked on something that we've been asked already, but I think there's clarification that businesses are looking for. And it's again related to independent contractors who are not employees. And the employers are now saying that due to the changing work circumstances, they would like to change the relationship to an employee-employer relationship. But I think in part it is, and it's an understanding to take advantage of the 75% subsidy that is there. And again, is this legal? Is this doable? And I think this puts you, Leanne, in a difficult position when asking that. But maybe if we take it on a broader term and understanding the implication of employers who have in the past significantly relied on contract workers and independent contractors to be able to make their business function, what position are they in?
A difficult one if they have not actually characterized the relationship correctly. What we saw with certain amendments to the Employment Standards Act some time ago, I'm going to say probably about a year ago, was an amendment that required an employer to prove that the relationship was a proper characterization. There was a presumption that a work relationship was one of employer-employee, and the employer therefore was required to prove all of the necessary elements or factors of independent contractor. I start from that premise because what we do know is the wage subsidy, again, from what we know now, the wage subsidy is provided to employers to provide a subsidy of up to 75% for an employee wage. Seems to me that that presumption, again, is employer-employee. If you have typically operated under a relationship of independent contractor and you are now trying to fit within the parameters of the subsidy, I expect that the application may be scrutinized. I expect that there may be further questions as to the appropriate characterization of the relationship, particularly given the recent change in the characterization by the parties to that relationship. And I expect that if the government concludes, or through the application process is able to conclude that there has been a misrepresentation or a fraud, what we have heard already from the federal government is that there will be consequences that follow.
Yeah. And I think that we really need to be aware of that. And I'm trying to get a little bit away from yesterday's announcement, last week's announcement. There's a question also, and I think it's a valid one. Employers are changing their business models around. They have to, in light of the circumstances that they find themselves in. So can an employer reduce wages, benefits, or change work locations? And what is the process that one should consider when they're going through that?
Right, right. Okay, so let's start again from the fact that wages, hours of work, duties and responsibilities are all typically considered material terms of an employment relationship. And so when we look at the reduction of wages, benefits, or change in work location, we want to ask to what extent? Because if, for example, I am reducing wages by more than, let's say, 12%, 15%, 20%, we know that we are getting into the risk zone of a constructive dismissal. The same goes for elimination of benefits. If I eliminate benefits that are customarily available to employees, that may trigger a constructive dismissal. So first and foremost, what we've been advising employers is have the discussion with the employee, because if they voluntarily agree, then you have minimized the risk of a constructive dismissal because it's not a unilateral imposed fundamental term. The question around work location. Generally speaking, if I am an employer and I change a work location that involves an expanded commute, that could have been grounds for a constructive dismissal. I'm assuming, or I'm going to make the assumption, that the change in work location in this question is really from a physical workplace to a home office. And in this climate, in the middle of a pandemic, it would seem to me that that change in work location would be reasonable and therefore not trigger a constructive dismissal.
Thank you, Leanne. Again, for all participants, just a quick reminder that the answers given on the webinar do not constitute legal advice, and that before anyone takes any actions, please consult with your own lawyer. I think it would be the right thing to do. Leanne, the questions are now when it comes to an employer who now is in the difficult position of having to terminate staff owing to the slowdown in business from COVID-19. What are the employer's obligations when terminating staff?
So that termination is without cause, as we know it. We know that an employer may terminate an employment relationship for just cause, in which case there's typically no obligations owed to an employee. But in a situation of a without cause termination, of course, the employer is required to look at what the employee's minimum statutory entitlements might be under the Employment Standards Act. And what we know in those circumstances is that an employee is entitled to 1 week's notice of termination or pay in lieu thereof for each year of service up to a maximum of 8 weeks. Where an employee has over 5 years of service and the employer has a payroll in Ontario of at least 2.5 million, there may be severance entitlements. And the severance entitlement is 1 week per year of service up to a maximum of 26 weeks. The severance entitlement may also apply in a situation of a mass termination. I won't get into that right now because that is very specific. The common misunderstanding that I see in our practice is that employers believe that if they comply with the employment standards minimums in the context of a termination, that they have fulfilled all of their legal obligations. The fact is that unless an employer has a valid enforceable employment agreement with a termination provision in that agreement that strictly complies with the employment standards minimums and or offers something greater than the ESA minimums, then the courts imply, the common law implies into that relationship an obligation to provide employees terminated without cause an entitlement called reasonable notice of termination or pay in lieu thereof at common law. and that includes the ESA minimums, but is often greater than those minimums. So we engage in an analysis on a case-by-case basis, having regard to a series of different factors, and we call them typically the Bardell factors. The Bardell factors are an employee's age, years of service, character of employment, duties and responsibilities. Are there any mitigating factors that may assist the employee in securing alternate comparable employment? Are there any aggravating factors? And the analysis involves the question of what reasonable period of time would this employee require to secure alternate comparable employment? What we did hear for a very long time is employers referring to what we call a rule of thumb, which is 1 month per year of service. And what we know is that our Court of Appeal of Ontario has specifically denounced that. They've said it places too much emphasis on the one factor of years of service within the Bardell factors. So a termination without cause during the COVID-19 pandemic involves the same analysis that you would take outside of the pandemic.
That's extremely helpful, because there have been quite a few notes that have been forwarded to us regarding this one, Leanne. This has been great. We're back to the impact of COVID-19, and in this particular case, and there was an employee who was supposed to return to work after 14 days of isolation, but has made the employer aware again that they've had likely a second exposure to COVID-19. And the employer is wondering how to best deal with it.
Again, if they have second exposure, or if they are required to care for an individual within their household who has been exposed or is vulnerable or has contracted COVID-19, you deal with it in the same circumstances as you did in the first instance, which is take the cautionary route, require the self-isolation or quarantine, consider whether or not you can engage that employee in a discussion around alternative remote work from home arrangements.
Okay, thank you. This is a question that has come forward. It's from a business owner who had to close their business, and they are considered a non-essential business. They have a staff member with underlying conditions who can't work from home, and in part it's also due to the responsibilities of that particular employee. And they're wondering if they're obliged to keep them on their payroll, or because of the subsidy, or if they can actually move forward to a temporary layoff, because they are uncertain about this one. The employee indicates they want to work. The employer is trying to do it right, but they really do not have the work and can't, due to their business not being open at the same time either.
Right. So again, I start off by saying it's important to understand whether or not the employer has the right to conduct a layoff through a contractual entitlement to implement a layoff. Regardless, if the employee agrees to that layoff and it's voluntary, then again, you've mitigated the risk of a constructive dismissal. And the layoff may be most appropriate where, as in this case, the employee has circumstances where they cannot work or they're unable to work because the nature of their position does not lend to a remote work from home circumstance. So in those circumstances where an employer is required to close their business because they are non-essential and there is no remote work from home opportunity, layoff is typically the response to that. And again, we've talked about those risks associated with the layoff.
Yeah. I noticed that in some of the questions, I think every employer has, it's such a unique situation that they're finding themselves in their employment relationship with their employee. that we hear that some of the questions are around the same topic, but I think it's really still important for us to hear the questions that are coming forward. And Leanne, thank you very much for clarifying it, because so much lies in the details of those arrangements. And this is another question. It's legislation around layoffs again. Under what circumstances and for how long are employers allowed to temporarily lay off people, and with what provisions? Now, it does look like that the government is looking at this particular clause and is reviewing it in light of the uncertainty of COVID-19 and the length of impact that it might have on so many businesses. But Leanne, what's your understanding of it?
That's right. So right now what we have is a statutory provision that defines what a temporary layoff is and the prescribed period of time for a layoff. And as I indicated, it's 13 weeks in any period of 20 consecutive weeks, or a layoff that lasts up to 35 weeks in any 52 consecutive week period where certain conditions are met. I had this question actually from a client yesterday, and certainly it's an unknown. What we can expect is that if the state of emergency continues for a period of time that is longer than the prescribed temporary layoffs, I anticipate that our government will do the right thing and will introduce amendments to those provisions in response to these very special circumstances. The other thing that we should understand is that if an employee agrees to a period of layoff that is longer than those prescribed, is that okay? Is that permitted by law? What we know is that we cannot contract out of the employment standards minimums, meaning we cannot agree by contract or agreement to change the statutory minimums. In other words, we can't agree to a period of layoff that is longer than prescribed currently. So again, I think that all of that lends to our government really having to consider a response to these difficult circumstances.
Can I also, there's a similar question that has come forward too, is that there's so many employers that are really not wishing to lay off their staff or to fully terminate them and make those changes. What are their rights to reduce it to a part-time situation versus keeping it at a full-time?
So again, the part-time versus full-time involves a change to a material term of the contract. Best course of action is to have that discussion with the employee, because the employee may voluntarily agree to a reduction in hours, because the compensation that they receive as a result of the reduced hours still may be in excess of the employment insurance benefit entitlement that they might have. So first of all, try and obtain the employee's consent. And if you have that consent, then implement the changes. If you don't, again, the same concern around constructive dismissal exists.
Yeah, that makes sense. This is coming from an owner. He or she is the owner of a company, and are they able to apply for EI or similar incentives for them at this time?
I'm not sure that I understand the question. Let me say that back. Just so that I understand, are they able, is there a subsidy or a employment insurance benefit for the owners of the company?
Yeah, it looks like the owner is looking for it because in the past, owners have not been able to apply for EI, but under these circumstances, this owner is wondering if anything is available to them as their business is closed for an undetermined period of time.
Right. So I'm not entirely certain whether those individuals or whether in those circumstances an employer would have access to, for example, the Canada Emergency Response Benefit. What we do know is that that benefit is available to a worker who has lost their job or income due to COVID-19, who are unable to work as a result of sickness or quarantine, and who may need to provide care to individuals who are sick or in quarantine. for many of the employers that we deal with who are looking for some form of alleviation of the financial responsibilities that they have, we're consider whether or not contacting landlords for deferral of rent, or contact your bank for increased lines of credit or what have you. Those are things that might alleviate the financial impact of the pandemic. But in terms of specific subsidy available to individuals who are officers, directors of a corporation or proprietorship, I think the question is one that is best answered on a case-by-case basis, and whether or not those circumstances meet the eligibility requirements of any of the employment insurance benefits available. So again, look at the emergency response benefit.
I also, if I could add,
Let me introduce actually to you Sheryl Johnson with Sullivan Mahoney, a partner with Sullivan Mahoney, has just been able to join us too. Sheryl, thank you very much for joining us, and the mic is all yours.
One thing, I'm not sure if this person meant to ask as well, because if they're an independent business owner, they would also qualify with regards to the CERB benefits. So if that was what was part of the intended question, then they would be entitled to the CERB benefits, because they've extended it to people who operate their own businesses, but as Leanne was saying, not employers of others, right? So if they're self-employed, they would be entitled to the CERB benefits. Just to cover that off in case that was part of the question.
No, totally, fully appreciate it, actually. One of the questions is, and I don't think we yet have all the answers to it, but it's back to the Canada Wage Emergency Subsidy and how to apply for it.
Well, I looked this morning, and actually, I went to the website, because they say to go to the website to find out how to apply. They don't have that in place yet, because we have to remember that that's still proposed legislation. It hasn't been finalized, nothing's been set in stone. So we're getting more details, but it's still speculative at this point until it's actually legislation. And so, and it's not actually going to be available until after, actually they say in 6 weeks. So with regards to the wage subsidies. And so if it's the wage subsidies 6 weeks, that's not going to be to mid-May. And so the CERB benefits aren't going to be available to be paid out until April 6th. So there's a bit of time still, but with regard to the wage subsidies, that is still proposed legislation. So we really don't have a lot of details now. They say to go to the Minister of Finance website to find out how to apply, and there's no details there yet. Yeah.
We have seen the same in yesterday's announcement by Finance Minister Monod. There's more information to come, and I encourage everyone. We are providing daily updates on our website at GNCC.ca. So if you have any questions, contact us and connect with us directly. The moment we have more information available on it, we will directly forward it to you, because it's a real critical question that's there. This one is a question, the best advice, or although we're not giving advice, but just for discussion purposes, can you provide for service-based hospitality companies regarding the short-term adaptation to this new situation? And I think a lot of the businesses are foreseeing that they are going to be closed for a significant period of time, and likely when they open again with a high number of restrictions. And again, I think employers are really, really wanting to keep their staff. They're wanting to keep that connection going. But what are their, in light of this uncertainty for the next month or 2 months, what are the best measures for someone in the hospitality industry? And I'm not sure, Sheryl, if you want to take it, and then maybe Leanne.
Sure. Really, at this point in time, it's, looking at projects they may have wanted to do, but haven't had the time to do it, looking at different marketing techniques, re-gearing. We're hoping that at the end of this, there's going to be a bit of a boom with regards to everyone being very excited to get out and about again and to have a service or to go to a restaurant where they haven't been able to do it for a long time. And so if there's things that you can do with regards to preparation and getting ready, because yes, that connection to the workplace and wanting those employees to be there, especially if it's a case that you expect to have a boom, that connection is very, very vital with your employees at this uncertain time.
Okay. And I think I'm looking at all the questions, and I think that we have probably answered most of them, and we're coming to the end of our webinar. Leanne and Sheryl, I thought I'll give the mic to you for maybe a last statement or comment for a minute maybe each, and then we can wrap it up.
I think that the message that is important to keep in mind is that as human beings, we crave predictability. We crave a measure of certainty. And right now, we don't have that in our workplaces. There's still many questions with respect to the subsidy, the work sharing program, the SERP. And so what we need to understand is that it's best to take a purposeful pause before we act and implement. Make sure that you contact your legal advisors, do your due diligence, do your research, and implement a decision that has been informed from a legal standpoint. Consider as well the importance and the value of your workplace relationships and the importance of communication to your employees, that they're valued, that you understand that these are difficult times, and that it's important to work together, because what we all want to do is get back to some sense of normalcy.
Yeah, that sounds very good. And Sheryl, to you. Sheryl, I can't hear you for some reason. Now I can hear you. Very good.
Okay. Not a problem. And I agree with everything that Leanne said wholeheartedly. And the only thing that I can really add to what she said was that, you know, even if you as an employer aren't feeling very calm and secure with regards to the situation, you want to express a certain level of calmness with regards to communication with your employees, because you're feeling uncertain, but I guarantee they're feeling even more uncertain than you are. And so, you know, having that dialogue and having that communication and making sure it's calm and considered communication is so important in order that we all get through this together.
And on that note, we will get through this together. It's the most uncertain time we have as businesses, and have weathered a lot of difficulties, this probably being one of the most significant ones that we can remember, but we will make it through this. Again, I wanted to remind everyone on the webinar that the answers were given during this webinar do not constitute legal advice, and that before anyone takes any actions, both as Leanne and Sheryl have said, please consult with your own lawyer and to get the right answers. It's critical in the relationships that we have built with staff and our team. Our team makes an organization. It allows us to do the things that we're able to do as a business, and it's critical that we get the right advice to support both sides actually in this. Today's webinar will be available on our website at gncc.ca and for everyone to access. Those of you who participated in it, we will email it to you directly as well. We are going to continue with our webinar series next week. So the next one is coming up on Tuesday at 10 o'clock, and then again on Thursday. And please stay posted, and we'll give you all the details shortly. So thank you, Leanne. Thank you, Sheryl, for your amazing insight in this very difficult, often very difficult topic especially for small to medium-sized employers. Your input has been incredible and very much appreciated. So from all of us, thank you very much, and keep well.